Hi, good evening, Dobbers. Welcome to another Wednesday evening CPD brought to you by Dr. Shield, who is our good friend who has been helping us organize this series of medical legal talks for you guys. Today's session is about hot tubbing, which is quite an intriguing title, and what doctors need to know. And the speaker is Mr. T. Taruma Raja, whom I'll introduce in a second. But before we do so, just a word from our organizer and friends, Dr. Shield. Okay, so just a brief video about Dr. Shield in case you don't know much about them.
We're Dr. Shield, and we do insurance differently than most companies. Things like simplifying details so it's easy to understand what makes us Malaysia's most innovative indemnity provider. As a Dr. Shield client, you'll enjoy comprehensive coverage with fewer exclusions. With some insurers, you'll only find out what's not covered when you make a claim. Our policy details are online and easy for everyone to understand. Competitive premiums that don't keep increasing. Many insurers increase their premiums across the board to compensate for losses. Dr. Shield limits the number of doctors insured from high-risk categories, so our premiums start fair and stay fair. Prompt dispute resolutions. We're pro-mediation because settlement and negotiation, instead of endless litigation, is better for everyone. Career and reputation protection. Typically, litigation can drain a doctor financially and emotionally. We limit the damage by both, so our clients emerge good names intact. And peace of mind, because a happy doctor is a good doctor. Our different approach to creating policies means we put you first, before us, so you can enjoy your career and sleep like a baby, even if you've just delivered one. Dr. Shield, insurance with a difference.
Thanks for your patience. So now I'd like to introduce our speaker, Mr. Taruma Raja, who is a senior partner with Aslin, Tunku Farid and Wong, who specializes in medical malpractice. So I'll bring Mr. Taruma Raja. Hi, good evening. How are you doing?
Good, doctor. How are you?
I'm well. So I'm sure the doctors are very keen because I had queries like, what is hot tubbing? You know, when you talk about hot tubbing, it conjures different kind of scenarios depending on what your concept of hot tubbing is. But I guess this is the medical legal version. So we are all keen and very interested to hear what you have to say. So without further ado, I'm going to share Mr. Taruma Raja's slides, and then I'll hand over the talk to him. So, yeah.
Can I proceed, doctor?
Oh, go ahead. All yours. The stage is yours.
Okay. All right. Okay, I'll start off with the definition. It's basically an informal name or description for the court process of calling expert witnesses to give evidence and to be cross-examined concurrently. So therefore, this begs the question, who is an expert? In this regard, I refer to the definition of expert provided for in the guidelines issued by the Malaysian Medical Council. This is what it says. A registered medical practitioner is qualified to testify as an expert witness if he has special knowledge, skill, experience, training, or education sufficient to qualify him as an expert on the subject to which his testimony relates. Such special knowledge, skill, experience, training, or education must be shown before the witness may testify as an expert. What is the role of an expert in a medical legal dispute? In this regard, I borrow the words of Justice Saunders in the case of Barclay versus Rice Thomas. This is what the judge has stated. If matters arise in our laws which concern other sciences and faculties, we commonly call for the aid of that science or faculty which it concerns, which is an honorable and commendable thing, for thereby it appears that we do not despise all other sciences but our own, but we approve of them and encourage them. Now, in Malaysia, we adopt what you call an adversarial system. This is basically a conventional method of adducing evidence. So in a trial proper, this is what happens. The experts engaged by parties will each prepare a report for use during a trial. The parties will then exchange their respective expert reports. The expert during trial will provide his or her evidence in chief in court in favor of the party instructing him or her. In this case, it will be the patient. He will then be subjected to cross-examination by the opponent's counsel, i.e. the healthcare provider. He will then be re-examined by the party instructing him or her. In contrast, hot tubbing, the procedure is slightly different. The experts engaged by the parties will each prepare a report. The parties will then exchange their respective expert reports. The presiding judge can direct the experts to meet and to draft what you call a joint statement, summarizing all areas of agreement and disagreement. And whenever there's a disagreement, the experts are supposed to state their reasons for the disagreement. The joint statement or report is prepared as a guide for the experts to give evidence concurrently at trial. At trial, the experts are sworn in and they will give evidence concurrently in a process which is akin to a discussion. The experts will be questioned by both judge and counsel. The experts will also be able to question the other. The whole process is controlled and managed by the judge. This process is a process where the expert evidence can be elicited with more input and assistance from the experts themselves. The objective is to identify the real dispute between the parties and to attempt resolution of the dispute in an amicable manner. What are the benefits of hot tubbing? Here, the experts will be able to interact freely. The experts will be able to ask each other questions without any inhibitions. The experts will be able to focus on the main or real issues in dispute. The experts will also be able to assist the court in having a better understanding of the real issues in dispute. Therefore, the areas in dispute can be narrowed. There'll be less arguments. There'll be mutual respect in the exchange of views between the experts. It will result in saving of court's time. What this means is basically the expert's time in the witness box will be reduced. There'll be savings in terms of cost, and counsel may have a very limited role to play. What are the drawbacks? There's a fear that the more senior, experienced, confident, assertive expert may overshadow the other. Now, in our rules of court, the rules of court were amended in 2012 to include a provision which empowers the court to direct the experts to meet. I refer to the relevant provision and I'll just briefly read through it. This is what it says. The court may at any stage direct a discussion between experts for the purpose of requiring them to identify the issues in the proceedings and where possible to reach an agreement on an issue. The court may specify the issues which the expert shall discuss. The court may also direct that following a discussion between the experts, they shall prepare a statement for the court showing the issues on which they agree and the issues on which they disagree, as well as a summary of their reasons for disagreeing. The contents of the discussion between the experts shall not be referred to at the trial unless parties agree. Where the experts reach an agreement on an issue during their discussion, that agreement shall not bind parties unless the parties agree to be bound by the agreement. I'll just refer to two cases where hot tubbing was successful and parties were able to reach a settlement, an amicable settlement. First case, this case involved a patient who was an elderly lady who was admitted into a private hospital after being diagnosed with osteoarthritis of her right hip. Following her admission, she underwent a right total hip replacement. The procedure was done under spinal anesthesia. The patient unfortunately suffered an anesthetic complication resulting in paralysis. The patient, being unhappy with the adverse outcome suffered, then commenced an action against the surgeon, the anesthetist, and the hospital. There were in total 5 experts appointed by both parties, 3 of which were orthopedic surgeons and the other 2 were anesthetists. This case was filed in a city south in the peninsula. To save time and cost, the presiding judge directed that the evidence of the experts be given concurrently. The judge then fixed a date for a meeting of the experts in Kuala Lumpur, since all the experts were from KL, on a Sunday, to facilitate the giving of evidence concurrently. The experts were given some time, approximately an hour, to have a private discussion. Subsequent discussions were done in the presence of the judge and counsel. It took approximately 3 to 4 hours. There was a question and answer session with the judge and counsel. It was interactive. The judge then directed counsel to draft a joint statement or a report summarizing all areas of agreement and disagreement, as well as the reasons for disagreement. Quite fortunately, the matter was able to be resolved amicably. Now refer to the second case. This case, the patient presented himself at the casualty department of a private hospital with complaints of feeling unwell after having dinner. He underwent a CT scan, which revealed a massive subarachnoid hemorrhage and was referred to a consultant neurosurgeon. Impression formed was that the patient suffered a massive subarachnoid hemorrhage with possibility of a ruptured aneurysm at the circle of Willis. As this facility did not have an interventional radiologist, the management plan was to stabilize the patient's blood pressure before transferring the patient to another facility to enable an angiogram and coiling to be performed. The patient unfortunately suffered an adverse outcome and became paralyzed. The patient, being unhappy with the adverse outcome suffered, then commenced an action against the neurosurgeon and the hospital. There were 3 experts appointed by the parties, all 3 of which were neurosurgeons. To save time and cost, the presiding judge directed for the meeting of the experts. The judge met the experts briefly for an introduction and then gave them some time, approximately an hour, to discuss the matter in private. The findings of the discussion were then relayed to counsel, and the judge directed a joint statement report to be prepared. Following the direction from the judge, a joint statement report was prepared summarizing the areas of agreement and disagreement. Again, fortunately, this matter was resolved amicably. So in conclusion, hot tubbing allows parties to focus on the real issues in dispute with the assistance of the experts testifying concurrently. It is generally likely to produce more answers of merit, which will be useful and helpful to a judge in arriving at a judge decision. Thank you. Dr. Allen?
I'm here, sorry. Yeah. Thank you. So that was short and sweet, very succinct, and at least now we understand what the hot tubbing is. Before we continue, I would like to remind you that our discussions would be preferably using Slido. So you can join us at slido.com and put in this code 68797. So that's where you have any questions to ask Mr. Taru, you can please ask at Slido, or if you're watching from DOPS Facebook, you feel free to ask questions in DOPS Facebook. All right. How common is hot tubbing in Malaysia compared to the conventional expert witness testimony and cross-examination?
Okay.
Out of curiosity.
Yeah, yes. Hot tubbing is not really very prevalent in this country. So far as my experience is concerned, there have been maybe about 10 to 15 cases where parties have attempted hot tubbing, and maybe in about 30% of the cases, the hot tubbing was successful. Unfortunately, in 70% of the cases, parties couldn't reach an agreement, and the matter then proceeded to trial.
And the reason for this lack of popularity, is it because it's a new concept, or
Yeah, I
doctors
think
don't
it's
like to get together, or what's the issue
I
here?
think it's still at the infancy stage, so parties may be a bit reluctant at this stage. And having said that, hot tubbing may not really result in savings. Like, especially for example, we've got now a matter in the East Coast. What happened here in this case, this particular patient was an elderly patient who suffered from cervical spondylosis and lumbar stenosis. He presented to the hospital with some pain in the back, and he saw the urologist and was diagnosed with stone in the ureter. He was advised to undergo the procedure. It appears that the anesthetist had initially attempted spinal, and the spinal wasn't successful. It was converted to general anesthesia. The procedure per se was uneventful. The patient was discharged about 3 days later. And 3 days after discharge, the patient comes back to the hospital complaining of limitations, severe weaknesses, and so on. He was referred to orthopedic surgeon, and MRI was done. It just revealed that cervical spondylosis and lumbar stenosis, cervical stenosis and lumbar spondylosis. He was treated conservatively. There was no improvement. The patient decided to get himself transferred to a private hospital in KL. He was under the care of a neurosurgeon. The neurosurgeon ordered an MRI. So when the MRI results came out, it revealed the presence of a hematoma. Okay, but since the surgeon was more concerned with the cervical stenosis, he did a procedure to attempt to alleviate the patient's complaints. The patient did not show any improvement, and a repeat MRI, which was done about 2 weeks later, seemed to suggest that there was a resolution of the hematoma. The patient continued to be treated in the hospital, and he came in on 2 occasions, 2 years later and 4 years later, to be treated for the disabilities and the weakness. The patient had filed an action against the doctors from the initial hospital, the urologist, the anesthetist at the hospital, claiming that the failed attempt at spinal anesthesia had either exaggerated or exacerbated his condition. And they seem to have some expert support. So they had commissioned an expert opinion from a well-known, renowned anesthetist from KL, as well as and a neurosurgeon as well. The defendants had commissioned expert opinion from a spine surgeon as well as from a urologist. In addition, given the fact that the plaintiff is now wheelchair-bound, both the plaintiff and the defendant had to seek an opinion from a rehabilitation expert. So all in there, about close to 5 to 6 experts. The matter had started, and as the matter was progressing very slowly, not due to anything, but because of this COVID, the pandemic, the judge advised parties to try to get the experts together to attempt to see whether there's a possibility of reaching some kind of agreement, if not a resolution. The issue here in this particular case was the cost, because one of the experts is from up north, 3 of them are from KL, and 2 of them are from the East Coast. So to trying to find a venue to get all these experts together may be costly in a situation like this. So therefore, we are at this point in time, both the defendants and the insurers or indemnifiers are unable to come up with some kind of agreement to proceed with hot tubbing. But we are still trying, and we hope to, have this matter resolved amicably, because we expect this matter to go on for at least 2 years, given the number of witnesses of fact and the fact that 6 experts are going to take the stand to testify in court. So it can be very time-consuming, and it also will be very draining in terms of cost.
Right. There's a question from one of our viewers, Dr. Shah Reza. Is this just like a subset of arbitration? He asked.
It's something similar to that, Dr. Shah. The objective is trying to get the experts to meet together to try to reach a resolution. Because in a medical malpractice claim, it is common for both the plaintiff and the defendants to commission an independent expert opinion. The idea is to establish if the care, management, and treatment rendered by the consultant was in accordance with acceptable medical practice. So basically, the courts are not very familiar with medical management. So therefore, they rely on guidance from the experts. So more often than not, whether you succeed or you fail in a claim will depend on the expert's testimony. So yes, it is something akin to an arbitration, and the main thing is to try to get parties to come to a resolution. That's why in medical legal disputes, it is very common to have for parties to have this matter mediated as well. So you go to an independent third party who is quite independent, who will listen to the evidence from both sides, in particular the expert testimony, and he will also try to help parties reach some kind of resolution.
So, what are the advantages of hot tubbing over conventional expert testimony? I think from, say, the doctor's point of view, one of the things about being asked to be an expert is we always have fear of trading in court and then, getting cross-examined by the other lawyer, and things sometimes can be quite unpleasant, if you know what I mean.
That's right.
Would it take away this sort of concern from the doctor's point of view?
Because you see what happens usually in a hot tubbing scenario, the experts are more comfortable because they meet together in private, they will have a discussion and then see their 10 issues. So more often than not, they may be able to come to an agreement on 3 or 4 issues, or maybe even 5. So the areas where they cannot reach an agreement will form the subject matter of the dispute. So when you go to court, they are a bit more relaxed. The inhibitions are not there, and when you have them both together at the same time, the trial proceeds more on, like what I said earlier in my slide, the benefit of it is akin to a discussion. So they're just proffering their views, they can put forward their views, and they can each question each other as well. They can put questions to the other, so that when you have the conventional method, usually there are some instances where the experts fear that they may be badgered, a counsel appearing for either party. And because of that, sometimes it's difficult for parties to be able to identify an expert who may be willing to come to court to testify. They may tell you, okay, I'm prepared to give you an opinion, but that's it. If you want me to come to court, I'm sorry, I'm not interested in coming to court.
Yeah.
So if you have hot tubbing, they may be more keen and to come forward and to assist parties because they want to help doctor as well as the patient to come to some kind of a settlement.
So where do they physically meet? Let's assume there's no COVID-19 and the doctors can meet. Do they have to be in the court premises, or can it be somewhere else?
The courts have provided us the rooms in court to enable parties to get together. Now, recently we had a matter where my client rented a room in one of the local hotels. Okay, the client paid for the rental. We got a very senior consultant to appear as the mediator. We got parties together. So you can either do it in private or you can do it in the court premises as well. The courts are very, very accommodating. And if parties are really genuine in having the matter, in trying to have the matter resolved amicably, the courts will come forward and provide the facility.
All right. Can it be in the era of COVID-19 be a virtual meeting like a Zoom meeting, or is that not allowed?
So far, I haven't come across a situation like that where the experts, I think the idea is to get them together. So there's no inhibitions, so they're more comfortable, they're a bit more settled,
Okay. To me, I can only foresee what you said. Sometimes, doctors have differing personalities and egos, and sometimes you may have a more dominant character in the group. And although you say hot tubbing with some consensus, sometimes it may not be so smooth as that. Do you see that as a problem?
Yes, because there have been instances where we've got very, very senior consultants and they just cannot come to an agreement on any of the issues at all. So in a situation like that, we consider the hot tubbing to have failed and we just proceed to trial. There's some of them who just refuse to budge, they refuse to hear the opinions from the other side, they just dismiss it completely.
So that is up to the judge, yeah?
Yes, correct.
If, so say I or somebody else, another colleague, will approach to be an expert witness, and we don't like this idea of being sitting in court, cross-examines, can we insist that we go for a hot tubbing procedure, or we say that sort of thing? Because it sounds a bit more. It sounds a bit more a better way to interact with your colleagues rather than be like adversaries on one side of the camp, and then the unpleasantries can arise when the witness expert testimony may differ in the court. Yeah.
Correct. If parties are available, more often than not they are, then we can address the court during the case, what you call a case management. So what happens is, in Malaysia, the system, the court takes control. So once the documents have all been filed and parties have commissioned respective expert opinions, more often than not, the judge will propose, or even parties can propose, if they can have a session where we can get the experts together. And so far, we have not encountered a problem where the court has refused any such request. The courts are in fact in favor of the experts getting together and trying to see as much, if the main objective is to see whether they can achieve a complete resolution. In the event complete resolution is not achievable, then the other option is to see if the experts can at least attempt to narrow down issues. So in the event the matter had to proceed to trial, we don't have to run through the expert report, subject the experts to lengthy cross-examination and so on. We can just narrow down those issues where we need guidance from the experts.
Right. Okay. Any other questions from you guys? It's an opportunity because it's actually quite new. I think most of us haven't heard of this hot tubbing. Now we know. And then, if it's becoming a bit more popular in the future, then at least we are better prepared. Let's see, there's not much other questions. I'm checking the Slido also, no questions at the moment. Have you got anything else to add, Mr. Taru?
Nothing at this point. Like what I said, it is something which is fairly at the infancy stage now. It's more common in construction disputes. It seems to basically picking up in medical legal disputes. And to me, I think I would recommend or strongly suggest having the experts together. Because like what I told you, I understand the predicament. When we approach experts, they say, must I come to court? I'll be cross-examined. I got to close my clinic. I got to spend 2 or 3 days there. Can't we have do we have any other options? This is a good option.
So it would save time. Generally, would that be the case? If we all meet together, and then come up with a consensus statement with agreement and disagreement. Can this hot tubbing also be part of medical mediation? We had another session earlier where instead of going to court, the mediation is the process, and in the process of mediation, you may need expert testimony. So can that be like a consensus or medical opinion in the mediation process as well? So
the concept is quite similar, to take it away from court and see whether parties can come to some kind of a resolution. Like mediation as well, the judge gets to get the parties in, so sometimes they get the experts in as well. Different judges have different ways of conducting the mediation. So some may see the parties together, or they may see them separately, and so I think the main objective is try to see whether it's possible to resolve the matter amicably without the need to go into a lengthy and costly trial.
Yes, thanks. Okay, let's check one more time. No further questions. So I think it's been very succinct and very clear, the concept. I think it's quite a neat way to gather expert testimony. Hopefully, we are never called up. We are never likely to be called up in court or anything. In my instance, I think I only had a couple of times only, and one time I had to go to East Malaysia, and it's quite a long process, and then call up. It takes expert testimony. Yeah, it was a nice time though to travel to a little town of Cebu and get to
Okay.
be shown around.
Okay. All right.
Sometimes there are benefits to being called as expert testimony,
That's right.
but it's still quite a daunting experience because coming to
Yeah.
court and then the seriousness of it all, and then you're sitting there alone, and then you get questioned, and then you get cross-examined and whatnot. So it is quite an
Okay.
experience. Yeah, but I
Yeah,
think
it can
hot
be
tubs
quite unpleasant at times.
yes, yes. So fortunately for me, it wasn't that bad. I mean, it's a quite straightforward testimony. But if it is a hot tubbing with your colleagues, sometimes it's more comfortable for us. I think it's like a
Yeah,
normal medical meeting.
that's right.
But I suppose unless in the group you have enemies in the group, then then there might be a different
Yeah.
matter. I mean,
Then can
human
be quite
dogs are
hostile,
also
huh?
human. Yeah, yeah. You could fight inside the group. I mean, you never know.
Mm.
Uh, yeah, there's one more question. Is it akin to maternal death inquiry in ONG practice or obstetrics practice? Well, is it akin to maternal
It's
death
not so
inquiry?
much of, I mean, I won't say so much of an inquiry in OB practice, because basically here, what it means, like what I told you, the whole procedure, huh? They prepare their reports and then they come before the judge. The judge will get them together in a private room, get them to sit down and see whether after spending about an hour or so, see whether they can come to some kind of an agreement, identify the issues which they have, the common issues where there's no dispute. And where there's actually a real disagreement, then they'll prepare a statement identifying the areas where they disagree and the reasons for the disagreement. I think in terms of that inquiry, the procedure is slightly different.
Mm, okay. Thank you for your question. Let's see. No, none on Slido. Yeah. Okay, I think we won't take too much of your time, Mr. Taru. And
No
what
worries.
I'll do now is show the code now where our doctors required to have CPD points at least every um, year. Now we have to have at least 20 points. So I don't know about lawyers. I think at the moment, I understand it's still not
Yeah.
compulsory. Yeah. So the code will be displayed in the next slide, and then you use the MMA app, click on the or tap on the scan QR code on the upper left of your profile, and here is the code. So I'm going to check and see whether it works. The MMA app server has been upgraded, so there shouldn't be so much performance issues like we experienced recently. So it should load. But if you have problems loading, let me know because we need to inform the technical people here. Yep, it seems to load well, and you can check by refreshing the points and see that it was recorded. Yeah, yep, the point is recorded. Works very well. Did you all get your points? Yeah. Okay. So it's quite a neat method, Mr. Taru. We have technology to
I understand
aid
that.
us to mark attendance.
Okay, all right. Okay.
Mm. Okay. Any last minute questions before we call it a day? And I don't want to take Mr. Taru's time. He's been kind to give us this talk, and he's still at his office. I
Yes,
believe you're still in the office, yeah. So we
yes, I
have
am.
to let you go soon, and so you can go back with your family and so on.
Thank
So
you.
if there's nothing further ado, I think we'll thank Mr. Taru for his excellent session on enlightening us what is hot tubbing from the medical legal perspective. So thank you once again, Mr. Taru, and
You're welcome.
good
Thank
night.
you.
Yeah, good
Good
night. Yeah.
night. Thank you for having me.
Okay. Okay. Bye
Okay.
bye.
Thank you. Good night. Bye bye.
Good night. So I'm going to leave the QR code screen on, and in case you didn't get a chance to scan, yeah. But don't forget the code will expire after about an hour, so you don't have much time to scan it. So after that, it will not work. So if you happen to be viewing this, say at 9:30 or something, please don't be surprised if the QR code doesn't work. Okay, all right. So I'm going to stop the live stream now and end the broadcast. But since you're viewing the video on Facebook, it will still be there for you to scan. Huh? You can scroll and up to that point. Okay. Thank you for your thank yous from Bernard and Shahrazad. Okay. All right. Good night, folks. There will be another CPD event in January, on the 9th of January. I'll announce it in the DOPS Facebook and Telegram group. It will be presented by the SGMC team once again, Cardiology Grand Rounds. Next week, Wednesday, I might take a break. It's been a very hectic, almost weekly CPD run, so we might just take a short break next week. If I have time, I might have a reboot event. But I think we'll take a year-end rest, so there might be none next Wednesday. But stay tuned in our DOPS Facebook and Telegram groups for any announcements, and that's how you will stay up to date with our CPD activities. So, all right. So good night, everyone, and have a pleasant rest of the week ahead.